Hello, dear guests. Welcome to One Fact and One Question. Throughout this program, we will give one fact and then we will ask our questions to our guest, Mr. Yavuz Aydın. Hello, Mr. Yavuz Aydın. Welcome to our program.
Hello. Thank you.
How are you?
Thank you. I'm fine. And whatever a refugee's life is like, mine is so.
Can you please introduce yourself just with one sentence to our listeners that maybe they don't know you? Just give one sentence about yourself.
Okay. My name is Yavuz Aydın. I was a judge in Turkey up until July 2016, and I worked at different levels and segments of judiciary. And now I'm a refugee among thousands of others in Belgium.
In Belgium.
Yeah.
If you are ready, I will start with our first fact, and then I will ask my question.
Okay.
Approximately 4,000 Turkish judges and prosecutors have been dismissed after the coup attempt in 2016. And many of them have been arrested and detained. So my question is, what are the grounds for a judge to be dismissed generally? And are there any international accepted principles which determine how and why a judge is dismissed?
So, to reply this question, let me just talk about the international standards about the judges and dismissals thereof. Yes, there are many international standards and documents about the judges and prosecutors, and these all focus on guarding and guaranteeing the independence of judges, guaranteeing their being immune from political or administrative interference. Among these documents, there are many among those of United Nations documents and principles, and many issued by Council of Europe, namely Consultative Council of European Judges, and Venice Commission has issued many interesting opinions and principles in this regard. And for dismissal to be regarded acceptable in the light of these documents and principles, first, these standards of independence should be in place and in practice. And secondly, there should be an effective judicial remedy in place to review the conformity with these international standards. So when we talk about Turkey, we cannot see neither of these two preconditions having been met.
Yeah, my second question would be also that, what do you think about the mass dismissals of judges and prosecutors in Turkey?
Yes. As I said, when we take these two criteria of being, having these standards to safeguard the judicial independence and having effective judicial remedy for the judges and for all other citizens, we don't see such a thing in today's Turkey. For Turkey, purge of these 4,000 judges and prosecutors was the beginning of the end in this regard, actually. And it seems to me that the 15th July constituted the perfect pretext for the Erdogan government to get rid of an independent judiciary. And only in this way it has been possible to commit all other atrocities and destroy the checks and balances system, which is crucial for the rule of law and functioning democracy. And from this point of view, it is the same approach as in Henry VI of Shakespeare. There is this Dick the Butcher, this character, and there is this very interesting sentence in this Henry VI, And this Dick the Butcher says, the first thing after the rebellion, let's kill all the lawyers. So it's the same since those times. So that's why, approximately, relatively closer times to Shakespeare, Montesquieu was talking about, the judges should be independent and the separation of powers. So it comes from centuries ago. But unfortunately, we don't have this now in place in Turkey.
So you also link this problem to the independent, not only inside the judiciary system, but also the system inside the state for the better conditioning, better functioning of a state. It's a must that these dismissals should be prevented if they are arbitrary, you say.
Of course, because, for a functioning democracy and for a functioning system of rule of law, this independence of judiciary and separation of powers is a must. And without independent judges, you cannot have independent justice and judiciary. Without independent judiciary, you cannot have a checks and balance system, which is crucial for the democracy and rule of law. So this is not only about the judges, for God's sake. This judicial independence itself is not for the judges themselves. This is for the citizens.
Yeah, I see. And I'm coming back to the dismissals of judges and prosecutors in Turkey.
Yeah.
Have there been any procedural and substantial miscarriages of justice in those dismissals? And do you think, if any, could you name and describe them, please?
Yeah. Even under current legislation in Turkey, the only legal ground to arrest a judge was, and still is, catching that judge red-handed while committing a crime which constitutes a heavy crime. So to give an example, like catching a judge or prosecutor red-handed while killing someone, or trying to, sabotaging something. So it should really be a red-handed situation. We call it in flagrante delicto in legal terms, in Latin. So even under these conditions, the competent court to arrest a judge is the assize court, which deals with the heaviest crimes, as a panel of 3 judges. In Turkish, we call them ağır ceza mahkemeleri, the assize courts to deal with these heavy crimes. And for the senior judges and members of the high appeal courts to arrest these people, it's the high courts. But however, thousands of judges and prosecutors have been arrested by the peace penal magistrates, which we call sulh ceza mahkemeleri in Turkish. And this is illegal. This is totally illegal. This is against the constitution. This is against the secondary legislation and everything.
And so what you say is, even the members of the constitutional court have been arrested by a decision by this first instance court of a local tribunal? Or is it real that in Turkey this happened?
This really happened, and just in the wake of this coup attempt. First thing in the morning on 16th of July 2016, even before many, these thousands of first instance court judges and prosecutors, they went to the houses of these 2 members of the Constitutional Court, and they arrested them in these peace penal magistracies. These are not even courts. Legally, these are so-called judges without courts. And these judges, these magistrates are only given the task to take this, pre-detention, the detention measures or seizure of some goods in the prosecution process. So these judges do not deal with other files, cases, and they do not conclude any legal or criminal dispute or any criminal investigation. They are there only for these measures. And it is definitely unconstitutional and illegal for these magistrates to just arrest even a first instance court judge. But they did the same for even the constitutional court and other high court members. So, and it had this chilling effect over the other courts. And these peace panel magistrates themselves were specially selected by the government-driven High Council of Judges and Prosecutors of the time. So they were the trusted ones. They were the accredited ones, and we have the evidence of this this claim I make in the number of dismissed peace panel magistrates. So among all 4,000 judges and prosecutors, there is only, we have only 3 peace panel magistrates having been dismissed. So this number, this more than 4,000 actually, it's 4,560. So this number corresponds to 1/3 of the whole judiciary in Turkey. So 1 in every 3 judges and prosecutors have been dismissed. But this number is only 3 among 700 peace panel magistrates. So these were already appointed as accredited ones a few months before this coup attempt by the Council of Judges and Prosecutors. And this is why this atrocity was in place. I mean, the arrest of these judges were delegated to these guys because it was guaranteed.
So what I see is that for these peace panel magistrates, I think we can have another episode, because as far as I see from what you say, these magistrates are really problematic, and really? I think they need to be analyzed in a more generalized frame. And I wanted to ask you, you already mentioned a bit, but to generalize a bit our discussion and to come to an end, what danger do you see could these dismissals imply? And as far as I see, you said already a chilling, you talked about the chilling effect. And what is this chilling effect, and what other dangers could these dismissals imply?
It was a huge move to dismiss almost 3,000 judges and prosecutors in the first few hours in the wake of the coup attempt on 16th July 2016. So this already had this chilling effect among all the judges and prosecutors. And later on, this number amounted to 4,560. So each day, almost each day, 50 more, 100 more, 200 more the other time. So mass dismissals continued for months. So every and each judge and prosecutor lived in this atmosphere of fear. They thought they were checking the official Gazette every day, I'm sure, to see if their names were on the new dismissal list. So can you imagine what kind of pressure it is because they already know that even those who arrested these colleagues know that there was no legal grounds to arrest these people. The only reason for these judges and prosecutors to be arrested was that their lists were sent to these guys by the government-controlled Council of Judges and Prosecutors. And on those papers in the file, there was only one paper, which was an Excel document printed with a tiny warning beneath the document saying that this list has been formed in accordance with the intelligence reports, and for this reason, this cannot be used as an evidence at the court. Even the intelligence agency guys, when sending these documents to these Council of Judges and Prosecutors and to the courts, they wrote this warning. But these guys at the peace panel magistrates, they didn't care because they felt and they saw that they were so secure under the new system. So this is the chilling effect, and this is the encouraging effect also from the other side, from the mercenaries, I call them mercenary side, and from the accredited judges side of the coin. It's like this. And to answer your question about what danger could there be as a result of this, so I can say that where there is no judicial independence and guarantees for the security of tenure of the judges, no single citizen is safe in that country. Because, as I said, judicial independence is not to protect the judges, but to protect the citizens, the investments, and the international obligations undertaken by that state, the democracy itself, and rule of law, which is the soul of the spirit of the state. So, from this point of view, I can say that whatever would happen after a successful coup has happened after these mass arrests and dismissals and the state of emergency being declared. I call it the real coup, actually. So, because after this, after silencing and purging so many judges and prosecutors with this chilling effect, and with the declaration of state of emergency, thanks to getting rid of these judges, they were able to exert all the pressure on media, on business world, and all other dissidents. So for that reason, it was really important.
I see. I really thank you, Mr. Yavuz Aydın.
Thank you.
This was a really fruitful discussion with you.
Thank you.
By myself, I really learned many things, and you really covered many different aspects of the issues with my short questions, actually. And thank you very much again.
I cannot stop speaking when I start.
No.
Thank you for framing it in a very nice way.
That was excellent. Actually, that was what I was waiting for, and I just got what I was thinking. So I'm so happy, and I also thank our listeners that for our first episode they are with us, and they listened to us till now. And if you also let me, Mr. Yavuz, I want to close this episode, and I thank you again. Thank you, dear listeners. You listened to one fact and one question from our guest, Mr. Yavuz Aydın, and see you in our next episodes. Goodbye.